All right, thanks very much. Now, this is a mention of the matter to try and work out what the next steps are and how we move this matter forward. Mr. Kuksal, that's something I wanted to inquire of you when I was looking through this last night, which is we have been dealing with the certain paragraphs in your amended summons, and there's also the originating motion. I am curious or trying to get straight in my head what the relationship between the originating motion and the summons is. I think that strictly the relief that's being sought in a proceeding commenced by originating motion should be the relief set out in the originating motion, and the summons is a way of getting the parties before the court or getting directions. Your amended summons has different relief to the originating motion. Now, I don't mind in one sense, so long as we all understand what's going on, but is it the situation that in this proceeding, the relief that you seek is that set out in the summons rather than the relief set out in the originating motion?
Oh, Your Honor, just for clarification, I want to note that it was my understanding that Your Honor's referring to the summons dated the 2nd of November 22.
Yes, that's correct.
Okay, now, in that document there are some 31 paragraphs. Is that right, Your Honor?
Yes, that's right. Yes.
Okay, so the only difference of any substance between this document or the relief sought for this document and the original one is the following. Firstly, it is explicitly asking the court to have the others take actions in respect of the publications that are first made on the website. In the originating motion, the publications are referred to, and the orders that are sought would have necessarily required the court to draw inferences about the lawfulness of the action of publishing the statements. So it's explicitly asking for something that was implicit to the relief that was sought in the originating motion. So that's one difference. The second difference is that at the time the originating motion was filed, the LSB had told me, foreshadowed, adverse consequences against Mr. Ansell if he did not breach privilege. During the course of the proceeding, the tort of the lawful act was affected. So the originating motion says that the court should determine and declare that the threat that was being made.
What paragraph are you talking about?
Just bear with me, I'm bringing up the originating motion now.
Because that starts, the originating motion is expressed to be in the heading as an originating motion for judicial review.
So it's paragraph 3 on P7. Order that the LSB renew the registration of Mr. Ansell's practicing certificate.
Hang on, let me go. So the paragraphs aren't consecutive, they start again. So Part A is judicial review and declaratory relief.
Part C.
Perhaps at judicial review.
It's at P7.
Yes.
Yes, P7. Order, paragraph 3. Order that the LSBC or LSB rather renew the registration of Mr. Ansell's practicing certificate.
Yes.
So basically what has been sought is mandamus, which is strictly within 56, Order 56.
Yes.
Now, so mandamus has been sought. What has now happened is they have made a decision, so to speak, which is not really a decision, as per the law. So you could look at it two ways. You could say that if you strictly followed the technicality of the law, then you'd say that they haven't made any decision at all. And they are required to make a decision as per the law. So then the originating motion falls. But because they had purportedly made a decision, what the summons tries to do is to cover another ground and say that, to the extent that they're saying they've made a decision, we're seeking certiorari.
The decision, which is the decision?
It was often used.
Is the decision not to renew or can't, whatever it was. The decision in relation to the practicing certificate.
Yes, so technically, as a matter of strict interpretation of the law, there has been no decision made, so we're asking the court to have them make a decision, but in the event that, they were to take a certain position about how it is in fact a decision, so that is speculative to that extent because right now we can't see, they haven't given us any evidence.
And that, just come back to, if you wouldn't mind to.
In my view.
The connection between the summons and the originating motion.
Yes, so this is the thing. Because they have purportedly made a decision, and to the extent that they may bring the legal argument which we have not anticipated that could form a justification for the decision that they've made, such that it could then be argued that a decision had technically been made, even if it was in error of law rather than an absence of exercise of jurisdiction or an excess of jurisdiction. So error of law, then we are asking the court to summons days to quash that decision and require them to make a decision that is strictly in accordance with the law. That's the difference. But as of now, opposition remains that they have not made any decision that. So,
am I correct in understanding it this way? The originating motion seeks relief on the basis that there has in law been no decision made in relation to the practicing certificate, because what is purported to be a decision isn't a real decision.
Absolutely.
And the summons is saying if it is a real decision, then it was made unlawfully and so forth.
Yes, so the difference, technical difference, Your Honor, is an error made within jurisdiction or in excess of jurisdiction.
All right,
So what we're saying is that, based on our understanding, and, Your Honor, when the summons were lodged we hadn't discovered all the material.
All right.
So now, because we have discovered all the material, we stick with the originating motion position in the sense that we're saying that they have not had jurisdiction to make the decision. What the summons was doing was essentially hedging our bets.
So what? Just direct me to the paragraph in the summons that, because when I look at the summons, the first paragraph is seeking declarations that appointments were effected for an improper purpose. Which doesn't that seem to have anything to do with the cancellation of the practicing certificate?
Yes, because the proceeding is much wider than just a practicing certificate.
Well,
The proceeding, the originating motion, seeks a whole lot more than the practicing certificate. The practicing certificate was.
yes, but Mr. Kuksal, I ask you why, what the relationship between the originating motion and the summons is, and you answer in the context of a decision, whether a decision was made technically or not made in relation to the practicing certificate.
I'm saying that's the only difference.
But,
Between the originating motion and so the two things I mentioned, Your Honor, if I may just clarify this for 1 minute. I mentioned that the only difference between the originating motion and the summons in relation to the specific orders that we're seeking is twofold. 1. We are asking the court to have the LSB specifically take action about the publications on their website, whereas
is this in the summons or the originating motion?
the summons, I'm saying this is the difference between the originating motion and the summons. The originating motion only seeks declaration that the publications are unlawful effectively, whereas the summons goes further and says that the court should also order them to take them down.
All right.
But so long as the court makes the declaration, they'd be in contempt if they didn't take them down, so it's sort of not strictly necessary. The second thing is that the originating motion, when it was lodged, no decision had been made. But an unlawful or a decision in excess of jurisdiction was present, so we were asking the court to have the LSBC make a lawful decision in respect of the practicing Mr. Ansell's practicing certificate. The summons then said that, if they come up with a justification because at the time we hadn't discovered the evidence and it turns out that they've made a decision in error of law rather than in excessive jurisdiction, then we're also seeking certiorari in addition to mandamus, but not that's unnecessary because we have discovered all the evidence and we know that the decision was made in excessive jurisdiction rather than in error of law. So those were the only two differences. Otherwise everything in the summons is in the originating motion and 4.
Is that right? So I'm just looking at the first. I was looking at paragraphs 1 to 3 of the summons, which are the bits that are being dealt with immediately. I couldn't, are they?
Page 4 of paragraph 5.
Page 4, paragraph.
It continues.
Well, so there's.
And paragraph 5 continues on to P5.
Yes, so.
So the Nayland appointment, the originating motion is seeking.
Yes, so they will. They were motivated by a part to verify preventative, so that, all right. So paragraph 5 of the originating motion says
that they were made for an improper purpose.
Yes, and identifies those purposes. And then paragraph 1 of the summons is really
paragraph 5 of the originating motion.
Yes, it is not obvious what the relationship,
it requires some.
But under the rules, what's in the originating motion and what is in a summons?
No, it's completely compatible with the rules. It's a complicated case. It's not put in the simplest manner. But it has.
But the point is that, do you accept that, say, for example, anyway, at the moment, we're proceeding with paragraphs, say, 1 to 3 of the summons, in the sense that's what's going to be determined first. And at earlier stages, you've said that that's the guts of the matter, so to speak.
No, that's not what I said. What I'd said was that would basically predispose, that will lead to determinations of fact which will create an issue estoppel in respect of all the other matters as well. So it's predetermined it.
Yes, all right, now.
That's what I said, Your Honor. I think Your Honor used a very reductionist.
Well, I might have misunderstood that.
I'm just speaking.
I'm not saying you've said it today. That's my memory from something that was sent at an earlier date.
Yes, and I think I had previously accused Your Honor of misreading what I'd said.
Yes, all right, so in any event.
So I'd reject the premise that what is sought in the summons is more or different than what is sought in the originating motion.
Right.
It strictly derives from the originating motion. It is a rephrasing of what is sought in the originating motion.
Anyway, you've had a look at it. You've satisfied yourself that it's in accordance with the rules.
Absolutely.
Yes.
I don't work for the government, so I don't really with those things.
Right. Now, at the summonses relating to the appointments of Mr. Nayland, Mr. Rapke and Mr. Cooper, what's the current state of play in relation to their appointments and their role?
Okay, so, Your Honor, before that, I must advise, for the sake of preserving a right, that we think that Your Honor's last judgment gives rise to additional grounds for seeking Your Honor's refusal, and we've planned on taking steps in relation to that in this proceeding. And I want to get to besides the recusal application. One of the steps that we intend to take is that we wish to add the Attorney General to this proceeding and the other proceeding, pursuant to our right under the Charter of Human Rights and Responsibilities. And we wish to add the Human Rights Commission to this proceeding and the other proceeding, meaning 3994, because
I can only really talk about this proceeding, I think, can't I?
No, I know, but I don't expect Your Honor to make any decision in respect of the other proceeding.
Yes.
But it would be misleading if I didn't mention that, because it applies to both. Because what Your Honor has done through the judgment is, in effect, say that the LSBC, irrespective of whether or not it lawfully makes a decision, it's...
Which judgment are you talking about? In this proceeding? Judgment in this proceeding?
No, 3994.
Right.
In 3994, the judgment that was passed on at the end of June. I believe it was just bear with me, I'm going to bring it up.
But what did I do by that? The judgment in which I did what?
Your Honor, if I just bring up
Was that the dismissal of the protective costs orders and the like?
Yep, well, technically we had never made those orders, made that application.
Yes.
What Your Honor had said.
No,
We could make the application, and then instead of saying that we did make the application, Your Honor implied, again in our view misleadingly, that we had made the application and that our application was dismissed when we had done nothing at all. That decision, yes. Now, what has happened in that decision, in our view, is that, just bear with me, Your Honor. I have, okay. So can we confirm the date of the decision, just for the record?
I think it might be, it's no 2024 VSC 367.
Yep, so
It's called Victorian Legal Services Board v. Kuksal, Actual Bias, Protected Costs and Stay, 2024.
It was made on the 26th of June.
I beg your pardon?
The judgment was published on the 26th of June.
That's right. And then there was a revision on the 27th of June.
Yes, that.
We fixed a typographical error.
That is the judgment I'm referring to. Now, what the court has done there, effectively, is said that irrespective of whether or not the LSBCACTS in the decision that it makes in respect of the renewal of a practicing certificate is beyond judicial review. That is incompatible with the Uniform Law, S463 of the Uniform Law. It's basically antithetical to the former due governance in the country and the rule of law. And if that decision was taken to be lawful, I mean, it's in excessive jurisdiction, so...
Right, yes. So just cutting to the chase.
Your Honor, let me just complete what I'm saying, because I'm not just saying that for the sake of criticizing the decision. But the practical effect of it is this: under the Charter of Human Rights and Responsibilities, I'm referring to sections, this is 36 and 38, or basically 32 to 38 are the sections on which I'm going to rely on now. Essentially, if the court makes a declaration that the operation of the law is such that it is immune or impervious to the considerations of the impact on human rights, and the legislation had not previously declared that, then the Attorney General must be notified that the court has effectively determined that a law operates in a way that abrogates human rights.
But I just need to mention, I can't hear I'm not going to determine the application today, but you're telling me you want to make an application to add the Attorney General.
I'm saying you don't have to, we have a right.
All right, but what are you?
We will add the Attorney General.
Are you seeking an order from me in relation to the Attorney General?
No. But I'm telling the court that the next step in both proceedings is raise a constitutional issue, notify the Attorney General that the court has determined this and seek to add them in the matter. What the court will have to, I guess what the court has to decide is whether there is no human rights issue arising and, therefore,
You say I have to determine that. What do you mean? I mean, you're going to communicate with the Attorney General.
Yes, but we will seek to add them, so there is a joinder application.
Well, when will that be and how will that be made?
So we have been preparing documents meticulously for some time now, and we anticipate that by the end of this week we would have prepared documents in relation to the, compounded evidence we have against the other.
Sorry, are you going to make an application that the Attorney General be added as a party?
Yes, but before we do that, we have to file the certificate that sets out specifically the constitutional issues that arise and the human rights issues that arise, and the addition of the Attorney General is subsequent to the identification of those issues.
All right. So you file a document relating to those issues and then what?
And then we have to serve it on the Attorney General that we state.
Okay, and then?
And after that we make an application for joinder of the Attorney General.
All right, so how is that? That's made by summons?
Yes.
All right, so.
And then the court has to determine whether
Whether to add the Attorney General.
Well, what the court has to decide is whether or not the human rights issues actually arise or not. Because if they do, then we have a right to add. So what the court has to decide is whether our assertion that the decision basically raises a determination in relation to human rights issues is correct or not at law. And if our assertion is founded in law, then we cannot add the Attorney General because of the right. The court then has to decide whether it will be in the interests of justice to add them, but if the court decides that the question of human rights actually arises, then we have a statutory right to add them.
Does the Attorney General have a right to intervene, or do you have the right to add the Attorney General against the Attorney's will?
We have a right to add them. The Charter of Human Rights gives us the right. I will refer to the section in particular.
Yes.
Just bear with me.
All right, so that is something that is to happen?
Yes, and it will happen. We will raise those issues early next week. By the end of this week, we intend to.
So that you will serve a document on the Attorney General?
Yes, first we will file it with the court. It's a document that sets out there are constitutional, that there are issues concerning the interpretation of the Constitution that arise in this document, and similarly, a document identifying the issues that arise in relation to interpretation of human rights.
So you file the document with the court, and then what do you do with it?
Then I would ultimately get a sealed copy that we serve it on everybody. On the Attorney General, and then we make an application for joinder. So, Your Honor, I'm relying on S35 of the Charter of Human Rights and Responsibilities. It says, a party to a proceeding must give notice in the prescribed form to the Attorney General and the Commission. This is the Human Rights Commission. Date, the state version, not the federal version of it. Commission F. In the case of the Supreme Court or County Court proceeding, a question of law arises that relates to the application of this charter, or a question arises with respect to the interpretation of the statutory provision in accordance with this charter, or in any case a question is referred to the Supreme Court under S33, which is basically that a question about human rights can be referred to the Supreme Court. And then sub S2 of S35, for the purpose of sub S1, a notice is not required to be given, so on and so forth. Then S36 says, declaration of inconsistent interpretation. This section applies if, so what we're saying is that the report has made a declaration of inconsistent interpretation.
All right, but where's the provision that gives you the right to add the Attorney General?
Yeah, I'm just taking the court to that. Bear with me. Okay, S34 actually, sub S1. The Attorney General may intervene in and may be joined as a party to.
So they don't have a right?
No, but so.
You can apply to have the Attorney General added?
So the second clause, and may be joined as a party to.
Yes.
So it may intervene themselves, or they may be joined as a party to.
Against their will?
We say that is the interpretation of it.
Yes. All right.
Because of the two separate things that are said.
All right.
That they can themselves do it, or they can be added as a party.
All right.
To a proceeding, but also we, against their will is.
What I mean by that is without their consent. I mean, the Attorney General can come along and say, I want to be part of this proceeding.
Exactly, but they can also be added to, is what it is.
Yes. If they say, I don't want to avail myself of the right to intervene, they can.
Well, then the court first have to decide whether they're saying that lawfully or not.
Yes.
Whether they're saying it in the performance of their duty or it's a person saying it against their duty. That's the first question that arises, and that will need to be determined.
All right, so that's one thing.
So we will add that to both 3994 in this proceeding. We're just preparing the.
But at the moment, there's nothing I have to do except wait. Because you're preparing a document you're going to file, and then you're going to, or try to file. I'm not sure, but.
You can make an order saying that we are to file it by that time if the.
Does the charter require you to file it or require you to serve it?
Yes.
I mean, does it require you to serve a filed copy or?
It's in the prescribed form.
Yes.
The prescribed form is certificate which needs to be filed with the court.
Yes, but I didn't understand that, from my understanding of that section, that the court has to approve in advance, so to speak, the form that you seek in it.
No, they don't. The court doesn't have any involvement in that.
Involvement, yes.
Yes, so we file it and then it gets served in.
But you seem to think that you can only serve a stamped copy? So a copy.
Yes, but the court, there's no judicial decision made about it.
Yes.
It's just for the registry. It's an administrative.
Yes, all right.
So that is basically to say that it was connected to this proceeding.
All right, We'll cross that bridge when we come to it then.
Yeah, but the relevance of that in relation to the directions hearing is this. We say that the court is improperly stopping us from issuing subpoenas and that.
I was going to ask you about that because I gave leave to issue a subpoena and yet you don't seem to have issued one.
No. So what happened, Your Honor, is that we have made applications for 2 subpoenas to be issued. The court didn't answer us in respect of one of the subpoenas. Still hasn't answered.
Sorry, I made a ruling that you could issue one but not the other.
Yes, and at the same time you said that I can send you an amended form of this other subpoena which is much more confined. I did file that. We queried with your chambers I think 4 or 5 times, all 3 of us, and your chambers said that you were looking at it and you will get back to us.
All right, this is the police one?
Yeah, this is the EMSA-NAS one rather than.
No, in this proceeding.
That predicament, yeah. Said yes to the commissioner, but it seeks information that will go toward implicating EMSA-NAS, and we said that is why the court is not issuing.
But what about the subpoena that I did give you leave to issue addressed to Fiona McClay?
Yes, so we filed that subpoena, except that all the documents that the Legal Services Commissioner had access to in relation to the 3 of us and the law firm or the law practice operated by People Shop. Those documents were being stopped for the subpoena. Now, after Your Honor made some comments about how broad it was and because of the decisions that Your Honor has made, we suspected that Your Honor was acting in bad faith and would improperly dismiss that subpoena. So to take some protective measure, we specified a couple of those documents in the body of the subpoena. That subpoena was not sealed by the registry.
Hang on, I gave you leave to file a subpoena in the form of that dated 29.
But you can't stop us from issuing a different subpoena at a later date.
All right, but am I correct in thinking that you have not filed a subpoena in accordance with the document dated the 29th of February?
It didn't look exactly the same, but it wasn't seeking any more documents.
It wasn't seeking any more documents?
That's right, it was not seeking any more documents. What it said is that the documents that we're seeking through the first subpoena, which is all the documents about the 3 of us, must include these documents which were about the 3 of us. It specified some of the documents that must be included in the broad definition, and the reason why we did that was because we suspected that Your Honor would just come along and say, "This is too broad, I dismiss it." Adding those 3 documents would have meant that Your Honor could not just dismiss it.
So when you say adding 3 documents, 3 categories of documents or?
No, we identified 3 redacted documents that they had given us previously which related to us, and we said, give us the unredacted versions of these documents as well when you're producing all the other things. And the registry refused after checking with Your Honor's chambers.
No, well, because it wasn't substantially in the form of that in which.
Well, Your Honor, no. That's wrong. I mean, for a layperson to say that would also suggest that.
But my understanding is that the document that you tried to file, I gave you leave to provide documents, and the schedule had 1 paragraph and then paragraphs 1, 2, 3, 4, 5, 6.
Yes, and then you refused.
And then you wanted to file a schedule that had document number 2, which was the unredacted version of documents included in the appendix. And paragraph 3, all documents in your or the LSB's possession concerning the costs incurred by the LSB arising out of 3. 1. Its investigation of Mr. Shivesh Kuksal, Mr. Ansell, Ms. Zhu, the firm AGLS, FX and Room Legal, and its involvement in or monitoring of proceedings involving Mr. Shivesh Kuksal, Mr. Peter Ansell, Ms. Lulu Zhu, the firm AGSL, FX and Room Legal.
This is already in paragraph 1.
Sorry?
This is already in paragraph 1.
So do you say that it didn't, in fact, add anything?
It didn't add any more documents.
Well, why did you?
Because that Your Honor was acting in bad faith and would what we wanted to do.
So let me get this right. So you presented a document to me in a limited form out of a concern that I would act in bad faith. You got leave to file the document in the limited form, and then you sought to file a document in the expanded form which you had not been prepared to show me and to seek leave in respect of.
It's the other way. It's the other way. The first document is basically broader, and so what the first document does is have only a broad clause in there.
Yes.
What the second document does is it tries to add a protection by also adding narrow categories, so if the broad category is rejected, which is
rejected by who?
By Your Honor.
You mean on an application by the board?
Yes, which was.
Because when you say rejected by me, I'd already given you leave to file it.
Yes, while saying that.
Yes, without prejudice to their right. Yes, I understand that.
Which was, in our view, improper. Because I've never seen a decision that said that.
All right.
And anyway, it was also emphatic. Contextually, it had some connotations. What we're saying is that we added narrower categories to the broad category because then it would have fortified us further.
All right.
And in any event, the fact is, Your Honor, we can file subpoenas at any time. We have a right to issue subpoenas. The court has an obligation to essentially seal the document so long as it is not an abuse of the court process.
Yes.
In our view, it is an unlawful abrogation of our right if the court is basically for semantics rejecting or curtailing our right to issue subpoenas, and a judge who does that will obviously not. There's a presumption that arises that he may not make the right decision in respect of the subpoena if they are already using semantics. The wording in the subpoena warns the recipient of the subpoena that they would not use semantic arguments to not comply with it, but they have to do everything they can to comply with it in good faith. And what the court was doing, in effect, was acting contrary to that principle and with all the other things, including the fact that Your Honor has, in our view, made a decision that predetermines Mr. Ansell's criminal guilt without any due causes, and my criminal guilt by extension, and Ms. Zhu's.
Okay.
Because what Your Honor is saying is that we're no longer protected by a section of the Uniform Law which applies to all persons employed by or connected with a law practice for them to prepare documents or engage in actions which would otherwise constitute unlawful, unqualified legal practice. So because that's a criminal contravention of the law that Your Honor has prejudged against us, and then coupled with all of those things, we think that it raises additional issues about Your Honor's impartiality, and those are also issues that need to be addressed in this proceeding. Now, we have also written to Your Honor's chambers and said that we wanted the decision about the subpoena because that's holding up our appeal application. We've largely finished the compilation of the appeal documents, but we need a decision about this so we can also add that to the appeal, and so we don't have to do it by amendment later on, add an additional fourth point to the appeal. So that was the other matter that I wanted to clarify, and we have written Your Honor's chambers repeatedly.
So what do you want? You want reasons for a decision, or you want a decision?
A decision. You have not decided whether you will issue or not the subpoena.
The subpoena to the Chief Commissioner?
Yes, that's right, and also.
All right. Well, I've given one and you say that you filed an amended document since then that I haven't given a decision on.
Yes, you've said that you haven't given the decision on that by email correspondence. Or your chambers has. I presumed that it was on your instructions, but they have said that you're considering it and that you will get back in due course, and it implied that we should stop chasing up on that because we had already done that 3 or 4 times. So this was several weeks ago. Then also in effect there has to be a decision made on whether or not we can file amended version of the subpoena addressed to the Commissioner.
All right. Okay. I'll try to get to the bottom of that, Mr. Kuksal.
So we wrote to the registry about the subpoena, and we said we will seek the court's leave to issue the modified subpoena to the Legal Services Commissioner, Fiona McClay, and we would like to modify the document.
Hang on. So I thought we were talking about the Police Commissioner.
No, both. So when the registry rejected the document in the manner in which we have filed it, this is the Legal Services Commissioner, Fiona McClay, the subpoena addressed to them.
Yes.
They asked us to file it in the same form in which Your Honor had approved, and when I say same form, I don't mean legal form, I mean the
same schedule.
Same schedule, literally. We then wrote back to the registry and we said that we had first filed the original subpoena with the same schedule that because we said to the registry that we wanted to take leave to file an amended subpoena, and we are taking leave now. This is the first opportunity that we have to take leave.
So what we're talking about now, is this the version of the subpoena addressed to Ms. McClay? Dated the 25th of June 2024?
That's when we had tried to file it, I think, yes.
No, I'm going from the date on a document that I've got in front of me.
Yep, so the content will not be the same. We want to further revise it because we will now specify all the documents.
So you still haven't, have you at the moment got an amended form of the subpoenas that you want to have leave to issue?
No, let me clarify this. We are not seeking any more documents, but we want to further particularize.
Okay, yes. But you've said that you are waiting on a decision from me in relation to a subpoena. Have you finalized the form of the subpoena in respect of which you want the decision from me?
We were waiting for a decision in respect of the subpoena that was filed on the 25th, but we've changed.
Which subpoena?
To Ms. McClay, that had included the additional 2 or 3 paragraphs that Your Honor read right now, which was the redacted version.
All right.
But I'm saying that there is no point in deciding that matter anymore because we will further.
No.
We will further particularize that subpoena. If Your Honor decided it and given us leave to file it, we would have filed it and issued it then.
All right.
But now that you haven't up until now, we will further particularize.
So you want to redraw the proposed subpoena?
Yep, not seek more documents.
No, but that's, yes, redraw the proposed subpoena to Ms. McClay.
Yes.
And what about the Chief Commissioner?
We're waiting on your decision.
But you're happy with the form you've got? The draft?
We will issue more subpoenas to the Commissioner after that. That's not the final. What we're doing is seeking whatever documents we can right now, but obviously nothing stops us from issuing more subpoenas. We have a right to, and we anticipate very much that those documents will reveal information and give us the basis to justify the issuing of more subpoenas.
Right, so there was a time when you were seeking to have your claim dealt with expeditiously and saying that you were basically ready to go with it, but I assume that your position now is that you can't have the relevant paragraphs of the amended summons determined until.
Yes, because we've discovered evidence against the LSBC in other proceedings, but we know now what we want and how we can, further demonstrate the conspiracy. And we also want to use the information we get, which is within our rights, to attack him before Parliament and a number of other executive bodies.
Now, I think I did mention something to you before, but we got diverted. I asked what the situation is with the appointment of Mr. Nayland, Mr. Cooper, and Mr. Rapke.
They were always unlawfully appointed, and that hasn't changed.
Yes, but what are they doing now?
Because they were lawful appointments.
Okay.
There was no with the law.
What's the current situation? I mean, what's happening with People's Shop?
Well, the LSBC is claiming that Mr. Rapke has effectively, What they are claiming is that after Mr. Rapke's appointment ended in February last year, the practice did not have a person connected with it who was authorized to run a legal practice in the sense of having a principal solicitor's practicing certificate. And, therefore, because the uniform law requires that a law practice must at any given time not operate for more than 2 weeks without a principal practicing solicitor, being in charge of it, the firm's registration was cancelled on that account, that no person connected with it was holding a principal solicitor's practicing certificate.
All right, so then we've got.
But what we're saying is that Mr. Ansell always did.
Yes.
So if he.
I understand that, but in terms of the second and fourth defendants, they are in fact no longer involved in the sense that their role ended last year, and you're left with what you say is a damaged business.
Well, Mr. Nayland was never involved when we launched this proceeding anyway.
No, yes, but what is the.
When we launched the proceeding.
What is the utility in making a declaration? What would be the utility in making a declaration that the appointment was invalid?
Because all the steps that they've then taken are unlawful, because the only reason why they're refusing to renew Mr. Ansell's practicing certificate is that he didn't cooperate with Mr. Nayland. If the Nayland appointment was wrong, Mr. Ansell's position is that Mr. Nayland was asking him to break the law, and he was of the view that Mr. Nayland's appointment was improper.
All right, well, I can understand why there might be a sense, then, that Mr. Ansell should have his practicing certificate reinstated or something like that. But why would a court just make? What would be the utility in the court making a declaration that an appointment?
Because we have a right.
Which is now finished, which is now over, was invalid.
Because it affected our rights, and we have a right pursuant to S36 of the Supreme Court Act to seek the declaration, and the court cannot say no because of.
And then what would happen?
What would happen is that they have seized $200,000 worth of assets from the entity, People's Shop. They're now wanting to return those. We're saying those are converted goods.
Yes. Well, this is what I was sort of getting at, then. So what then happens, once a declaration's been made?
So that.
What purpose does it serve?
It predetermines misfeasance and it predetermines professional misconduct, and, we do whatever we can to punish them with those determinations in whatever manner is lawful.
In separate proceedings to be issued?
In separate proceedings or further addition to this proceeding or whatever. That's up to us, whatever the law allows us to do. But we have a right to demand that the court address this matter. There is no lawful purpose for which the court will not address this matter, because it's also a public interest matter necessarily. And we will, that matter is predetermined, that it's a public interest matter. The statute does not leave it to the discretion of the court. It's a public.
But the goods you're talking about, so there's valuable assets of People's Shop Pty Limited that were seized that you say have been damaged.
No, they were seized. So that whatever was in the offices of the firm was never returned to us, the furnishings, the electronic devices, the computers. There were.
Where are they now? Do you know?
They're with them.
Yes.
They're with them. They took them and they never returned them.
And did you tell me before that they've offered them back and you have said?
Only 2 years later.
Yes.
Now they've said, so we were suing them. What I did then was I subpoenaed every device that they had because it had information.
In which proceeding?
In another proceeding. And then they said that, okay, they'll give it to us because they couldn't afford that subpoena. I subpoenaed all the electronic devices they were holding in another proceeding.
Yes.
And in response to that, they said they will release the goods. We are.
So you haven't taken the goods, though?
No, but that wasn't all the goods anyway.
Okay.
It was just, and.
And who owns the goods? People Shop Pty Limited?
I do.
So they weren't People Shop's goods. They were your goods.
My goods, Miss Zoo's goods. I don't know if Mr. Ansell had any personal property there, but I personally owned the goods, and Miss Zoo did personally own the goods.
Yes.
And they knew that. And also, Your Honor.
All right, but the point of view, so.
No, there's breach of legal privilege.
You want the declarations of misconduct so that they can be then used by you in the next steps you wish to take.
That, and I want my property back. They have my case files, my privileged material they're holding, and what they're doing with the privileged, well, they've already done. This is, again, an admitted fact. We have an email between Mr. Howard, who is the police officer accompanying Mr. Bowes.
No, that's all right. Look, I don't need to get into the detail of the evidence, Mr. Kuksal. I'm
saying that
reflecting on the fact that
the police
originating motions are really supposed to be cases where there's not a lot of contested facts.
That's not true.
Yes.
That is fundamentally not true, and also, as a matter of fact, there are no contested facts here because they're not contesting those facts. What Your Honor is saying is we're making allegations that basically bring the administration of justice into scandal. But it's uncontested that has happened.
That what has happened?
They brought in a current affair reporter.
Yes, no, look, Mr. Kuksal, I readily understand your concern at the fact that a current affair were mysteriously.
Not concern, Your Honor, outrage. And the outrage was that they did it so blatantly as to imply that I was powerless to hold them to account. That's what I'm outraged about more than anything else. That it implies that I, despite the fact that they're giving me so much evidence, they're acting as if they operate with some sort of impunity, which can only be true if I was fundamentally incapable of.
All right, so what orders do you say I should be making today? We're talking about the subpoenas, so you were awaiting a decision from a different form of subpoena addressed to the Chief Commissioner. You want to redraw the subpoena to Ms. Maclay and get a decision from me in relation to that. You want to serve, finalize and then serve on the Attorney General and file with the court a document indicating that the Attorneys General should be involved. You want to then, if the Attorney General doesn't itself intervene, you want to make an application to add the Attorney General to this.
It's not if we will make an application to add them and the Human Rights Commission.
Well, that's if they don't avail themselves of their right to come along and apply themselves.
No, that's not. The law does not require us to wait for them. And then, Your Honor, if I could just point out the section that allows us to join the Human Rights Commission as well. Just bear with me. That's the SOS 40 of the Charter. This is the Commission named to be, and may be joined as a party too.
Same sort of format.
And we have authorities, we will identify precedent where.
So for these, you would resist any order from me, then, setting this matter down for hearing at the moment?
Absolutely, but also, again, for the sake of formality, if not anything else, we are making an application for Your Honor's recusal because we're saying that what Your Honor has done in predetermining our criminal guilt by saying that the LSBC's decision in respect of the non-renewal is effectively beyond judicial review in the sense of finding it null and void.
Is this the bit where I said it should be complied with until such time, if it's found?
Yes, that's against the law. That's against S-463 of the Uniform Law, which says that if the court finds that the decision was invalid, it's as if the decision was never made. Also, let me contextualize that further. The court can find that even though the decision was invalid, it should have effect until this time or that time. And the court has to consider the evidence and make.
What section of the Uniform Law was that?
I think it's 463, but I'm
463.
Confirm that.
All right. So you're making, when you say as a matter of formality,
Yes, it's decision on appeal or review. This section applies S-463. This section applies if the decision under this law, made by a decision maker, can be the subject of an appeal or review to a court or tribunal. Subs. 2. If the decision of the superior court or tribunal varies or is made in substitution for the decision of the original decision maker, the decision of the superior court or tribunal is taken to be the decision of the original decision maker other than for the purposes of a further appeal or review by the superior court.
What section are you reading from? 363.
463.
463. Yes.
Yes, subs. 2 and.
All right, so you, says, yes, well.
And b. To have had effect as the decision of the original decision maker on and from the date of the original decision maker's actual decision unless the superior court says otherwise. So, but the default position is that if the court finds that they have acted unlawfully in not renewing or unreasonably,
Yes. No, I understand your point.
then they have renewed it.
Yes.
Now, what the court has done is basically flipped the presumption and said that the presumption is the other way round.
Yes.
Now, the consequences of that in doing so, the court has flipped the criminal, the liability for criminal conduct, because if Mr. Ansell is in fact, if his practicing certificate was not issued, and then the court has also made further comments about how the documents that were prepared on their face give the impression that they were legal documents that should be prepared by a solicitor. What the court has indicated is that it has predetermined that Mr. Ansell has acted in contravention of the section of the Uniform Law which bans unqualified legal practice. If that is the case, then what the court has also implicitly determined is that the protection that I have and Ms. Zhu has, as agents of a law practice in relation to allegations of unqualified legal practice, do not apply as well. Now, those are criminal law provisions, and Your Honor has taken away our human right that arises from S24 and 25 of our human right that arises from S24 and 25 of.
And This is the same point that you say engages the interest of the Attorney General and the Human Rights Commission.
Yes, but there.
No, I can understand. You're making a recusal application.
Well, what I'm saying is Your Honor has already prejudged it and will not actually honestly decide the application, that's what I say.
Okay, yes.
Because, you know, of our previous matters. But Your Honor is required to give a decision and we require reasons for the decision.
Yes.
Now, what we're also saying is that, I might also add this, the decision was not only a requirement to the law, but it was also, in my view, morally perverse. Because it calls into question and by the way, I have quotes from the High Court which effectively say the same thing, that a system of governance where the executive has a final say on matters of property or criminal liability is a tyrannical form of government. What the court has basically done is condoned a tyrannical version of government, and we say that I'm speaking for myself in this respect only, I say that is morally perverse. And a person acting in good conscience and
So can I just say it's morally perverse to take the view that a solicitor should cease acting as a solicitor whilst their practicing certificate has been cancelled pending a determination by a court as to whether that cancellation was valid?
No, it's more, I think Your Honor is twisting my words.
How?
Okay, but please let me explain that, 2 minutes. It's morally perverse to say that a solicitor who accuses an executive body of trying to intimidate him into sabotaging his client's interests goes to the court and says that this is what the body is doing, whilst the body continues to take detrimental action against him, suspends his license after he goes to the court.
Yes.
And there is clear evidence that body has had a tabloid reporter who is being sued for defamation record the content. Basically, what they've done, and there is no contest about this. Your Honor has already made a finding of fact in a judgment which we had identified in the previous correspondence. What they have done are the elements of contempt of court. And what the quote said was that despite all of that, if the executive body is saying that you can't do something. You can't do that thing. So, basically, what the court is saying is that body can take whatever detrimental action and Mr. Ansell does not have the protection of the law. That's why it's morally perverse.
Right.
And I think we will present evidence about this. A big part of the work that we've done in this matter is the formulation of universally applicable principles in relation to malicious abuse of authority. We've preformed a very thorough inquiry into how those matters can be identified. And the only manner in which such a decision could be justified is if Your Honor removes contextual information from the relevant consideration before making the decision. And that's what Your Honor was doing right now by implying that.
Well, look, I see it differently. I see that you pose the hypothesis of what is morally correct, starting with the proposition that Mr. Ansell is innocent and the board is acting maliciously.
No, I started with the proposition that when he applied to the court, his practicing certificate had not been cancelled.
Yes, but at the time that you started your analysis on the basis that as from the time his practicing certificate had been cancelled.
Yes, that was after.
Was acting improperly.
Your Honor, first of all.
So what if the morally correct thing to do?
Okay.
Is one deals with a situation where a practicing certificate has been cancelled, and no one is in a position then to decide who is acting in the right and who is acting in the wrong.
Okay, so let's just clarify this.
It might be we're wasting time.
No, Your Honor, this is a very important thing and I want Your Honor to address this in the reasons. What has happened is that Mr. Ansell made a public interest disclosure that he was being threatened to lie and fabricate evidence against his client. He went to the court, and after he went to the court, the LSB, the executive body, then cancelled his license, supposedly after he went to the court. And we're now saying that the court must decide whether this was detrimental action or not. And the court is saying that it's not going to decide whether it was detrimental action or not because they've already taken it. That's why it's morally perverse. I'm not starting with the presumption that Mr. Ansell's allegation was correct. By the way, there are admitted facts about that allegation which the LSBC can't escape. There's criminal conduct was committed. But let's keep that aside for a moment. What I'm saying is that the court did not. The court effectively committed a fraud in implying that Mr. Ansell came to the court after his practicing certificate had been cancelled. That's a natural implication if one were to read Your Honour's orders. But he came to the court before that and he said that they're basically already squeezing me to lie and to misquote, and I suspect that they will take further adverse action because they've told me that they will not stop until they've done everything harmful against me. Single quote. And then the court says that, well, if they've done it, they've done it. No need crying over spilt milk. That's what is perverse. What the court has effectively said is that there is no accountability for the executive. The Judiciary Act prevents the court from doing that. The Crown Proceedings Act prevents the court from doing that. When the executive is before the court as a party, they have the same standing as any other party. And I say it's morally perverse because, Your Honour, in countries where they don't have these laws, they still have people, protesting against such action.
All right.
And China and Russia and other places attack lawyers and throws them in jail for the same kind of thing. And those lawyers still know that they're right, even though there are no laws in those countries that criminalize that conduct. And those lawyers get support from everywhere around the world because it's a human right to be able to stand with one's conscience.
Right, all right, so there's a recusal application that.
And so the other point is that even when we have pointed out after that the court doubles down on its decision and affirms that that is exactly what it had done in terms of predetermination of Mr. Ansell's guilt. So we had raised this matter before the judgment of 26 came out that the court had effectively ignored the operation of S463 and a number of other things. And the critical aspect of this is that the court has done this to prevent Mr. Ansell from being able to get evidence or rely on evidence. That decision was to prevent him from using evidence of the LSBC's malfeasance in defense of the criminal allegation that they haven't even honestly made against him, but the court is agreeing to presume that they have made and they are entitled to make, and so on. So,
what is the paragraph of the malfeasance that we're talking about?
Your Honour, it's the part where Your Honour says that I see. It's the part where the court says that the refusal was sought on the basis that Mr. Ansell's criminal guilt had been predetermined. And, again, quite improperly.
No, I just want to find it now because I don't want to have any trouble. Which decision is it? In what proceeding?
It's the 3994. But the same issues arise in this proceeding, so.
No, but the paragraph you are referring to is in the 3994 and the decision that came out.
On the 26th, revised on the
26th of June. I am just looking for I have got that in front of me.
I'm trying to find the published reasons. Can you send me a copy of the reasons? Your Honour, could I have the citation for them, please?
Well, the one I have got in front of me is 2024, VSC 367.
Yes.
Your Honour, might I be permitted to interrupt to assist here?
Yes.
I think, Mr. Kuksal, the other citation is 2024, VSC 291.
Which case is that in?
The 03994 proceeding.
Okay, I found the paragraph, Your Honour. It's at paragraph.
Yes, so which proceeding?
The one that Your Honour pointed out. 367.
Yes, what paragraph?
It's paragraph 6. I have, however, considered Mr. Kuksal's letter. Single quote.
Yes.
He contends that Victoria Police and the board conspired to cause him harm, that the board maliciously abused its authority, and that various people, so on and so forth.
Yes.
And it goes on to say, condemn Mr. Ansell to be effectively convicted of a criminal offence. Now, we think, no. I speak on behalf of the other plaintiffs as well in this respect. We say that, in the court, not addressing whether or not it had actually done that brought the administration of justice into disrepute in accordance with the principles set out in Strickland v. the Commissioner of, Strickland v. Director of Public Prosecutions, 100th. And I want to read one paragraph in particular, or.
Before you do, just clarify it. So the recusal application focuses on paragraph 6 of 2024, VSC 367, and the central contention is that, by failing to address the validity of those assertions that are set out, that is, whether they are right or not, the administration of justice is brought into disrepute.
We say that, implicitly, the court has accepted that that is what has happened and then ruled that that is not a basis to seek recusal. And we say that that is the natural implication that arises because no judge would otherwise leave that sort of allegation unanswered.
But when you say unanswered, you mean without findings made as to whether they are valid or not.
Yes, because what we're saying is that a judge is acting in concert with an administrative body or is refusing, effectively, because it is refusing to hold the body to account. And if the court doesn't address that allegation, then it is.
All right, I understand.
Grossly dishonorable conduct and not a conduct that can be associated with.
How would it be addressed? By looking into the evidence and making findings of fact?
No, you could have simply said that you have not made any finding of criminal guilt and then explained how we have been misguided in inferring that or in coming to that conclusion. You could have said that, well, you couldn't have actually logically reasoned it because, and that's why I suspect you didn't try to, but the problem is in saying that Mr. Ansell either has a practicing certificate or he doesn't, and…
No, I think you are confusing.
No, this is the same thing, Your Honor. This is the same thing. So this…
But that paragraph about whether he had a practicing certificate or not, that is not in this decision.
No, but it's an implication of that. The letter had linked that decision to the finding of criminal guilt. And I'm saying in actually addressing or trying to clarify that we were wrong and you had not done that, you would have then had to explain, which was impossible, how your decision that, if the board says he doesn't have a practicing certificate, he doesn't have a practicing certificate, and that it is arguable that he has prepared legal documents that only a solicitor can make, how that does not necessarily predetermine at least some aspects of whether or not Mr. Ansell has committed a criminal offense. And Cable v. DPP is critical in this respect, that the authority from me.
Let me just interrupt for a bit. Mr. McAuliffe, were you trying to identify for me the paragraph in the decision I made which dealt with this other issue, which is the suggestion that the decision of the board should be complied with pending a determination?
I was attempting to, yes. I had understood that really, was the 291 decision.
Yes. What paragraph? I have got that. So that is 2024.
I had thought it was paragraph 6.
All right.
Well, I mean, you know, Mr. McAuliffe and I often disagree about things.
Yes.
For instance, he has.
No, but, Mr. Kuksal, he was helping you out, in this sense.
Well, he's not helping me out. He was trying to.
Mr. Kuksal, you identify.
Well, I have appeared before him in several proceedings.
Mr. Kuksal, you identify for me, then, please, the decision in the paragraph that you rely on where I said words to the effect that, if a practicing certificate has been cancelled, then people have to work on the basis that that is a correct decision until such time as it has been set aside, or words to that effect. Whatever I said, but you said you rely on that.
Yes.
I am just trying to make a note of exactly, in all the various decisions that have been made, where it is.
Okay, I think, Your Honor, I had quoted it in the letter that has been written to the court.
I am not interested in, I just want you to tell me where it is.
Okay, this was the decisioner, just bear, I'm bringing up the…
Which proceeding, for a start?
It was 3994. It was the rejection of the subpoena on the basis that the evidence could not help him.
Okay.
Because ultimately, the decision that is…
All right, well, that will help me find it. Paragraph 24.
So Mr. McAuliffe was wrong there, as well, because he was saying paragraph 6. I note that.
Yes, well, yes, at least he had the right decision.
Well, I think.
Yes, I have got that. Paragraph 24, Mr. Kuksal.
If is, yes, I don't have the order in front of me, so I'll take Your Honor's word for it, but…
The reasons, well, just so you know, that is the paragraph in which I say, it is clear beyond any sensible argument that if a lawyer like Mr. Ansell has had his practicing certificate cancelled or revoked or not renewed by the board, then that person is thereafter not entitled to practice. If, in due course, it is established that the board was wrong to cancel or revoke on review, etc., then the right to practice would return, but until that happens, the person is not entitled to engage in legal practice. That is the part that…
Yes, I think Your Honor was legislating there, because…
Yes, but I am just clarifying that that is the passage you are relying on.
Yes, that's not what the lawyers…
All right.
And that was not enforcement of the current law.
All right.
But it's…
All right, so you rely on that paragraph and paragraph 6 of the other decision in the recusal application.
Well, those are some of the things that we rely on. Yes.
Yes, all right.
But, Your Honor, if I could just read from the Strickland decision. This is paragraph 153 in Strickland, and this is from the judgment of now Chief Justice Gageler. Ours is not a system of justice in which courts and law enforcement agencies exist in some sort of continuum. Between the two, there is a sharp, constitutionally mandated division. Courts, in exercising their own powers, should be careful to guard against creating a tendency for the public perception of that division to become blurred. Single quote.
Right.
And the High Court went on to say that when that happens, it brings the administration of justice into disrepute.
All right.
When it happens, when there is an indication that the court is rubber-stamping the decision of an executive body or treating the executive, in fact, what the court said in Strickland is that this is by implication of what they said actually, that because both parties are to be treated equally, a subject and any agency of the state, but because the court has to be extra careful in distancing itself from the executive, and because of the operation of the modern litigant obligations, the court is tougher and more, well, it's more stricter with the executive than it is with the subjects. And this is confounded by the fact that Your Honor has previously found that when the LSBC brought the law, in particular, regulation, I believe it's 46.05 of the General Civil Procedure Rules, in not serving us the summons.
Yes.
And Registrar Keith also brought the law.
Mr. Kuksal, this is old news though now.
No, it adds to that, Your Honor. It's the same judge doing it after finding just 46.5 is the regulation. Justice Registrar Keith was not entitled to suspend the operation of that particular regulation, only a judge can. What the court found was that, even though the LSBC had broken the law and
broken the law in the sense of not
complied with the regulation, not complied with the regulations, yes.
The regulation being that the law of court.
It was on the summons. And, Your Honor.
Yes.
I have said that that was more a mischief because that summons in itself.
Yes.
No, Your Honor, that.
Mr. Kuksal, no, Mr. Kuksal. I am not going to hear another argument about this.
No, another 30 seconds.
I have heard your argument before.
We have amended.
Could you please put Mr. Kuksal on mute? Mr. Kuksal, I am not going to go back into that argument. I have already made my decision, my view on that plain in the decision I made in the appeal against the judicial registrar's orders, that I thought that he hadn't done anything wrong in the way he dealt with the summons. Now you can criticize that all you like, and there's no point, and I don't expect you to agree with me, but there's no point. We're just wasting time with you re-agitating that argument. Now, take Mr. Kuksal, take him off mute, please. So what else is there to say on the recusal application?
So, Your Honor, I wasn't just reiterating what I had previously said for the sake of criticizing, Your Honor. I was saying that because after that, Your Honor has also allowed the LSBC recently, last month, to amend the very summons.
Really?
Because it was central to my argument that those summons were so defective that they weren't honestly lodged and they could not have been argued and they were just lodged to create mischief at the time. And they could not maintain that, to a hearing.
All right.
Then they came around and you allowed them to amend that too, after prejudicing us in respect of the first summons.
All right.
You made decisions against us and you also have awarded a lump sum cost order which the LSBC has used to commence bankruptcy or to initiate, well, they've sent us a threat saying that they will, without further notice, issue bankruptcy proceedings. On the basis of the lump sum order that you made, without hearing us about whether or not a lump sum order should be made, by the way.
No.
And after all of that, you then allowed them to amend the summons.
Yes.
Which basically had confirmed what I had said.
All right.
And you have never addressed how they did not contravene 46.05. I suspect and I allege that Your Honor did not know that at the time when Your Honor first made the decision. And now, even when it's indefensible because I have identified the statute, Your Honor is not addressing the substance of my allegation that whether or not they were allowed to do it in light of the specific regulation that I have identified and is simply hiding behind technicalities and abusing authority. Discretion is given so that the court can do justice in accordance with, a complex set of circumstances. It is not given so that the court can basically get away with either ineptitude or just sheer apathy.
So, right. All right, I'll have another look at 46.05 of the rules.
46.05, yes. And Your Honor has not identified a way in which what they've could be done lawfully or what Judicial Registrar Keith did could be done lawfully.
Yes.
And the fact is that I had already
All right.
Sworn, foreshadowed, and the courts that was the mischief that they were perpetrating and in those circumstances, and Your Honor, the simple fact is this. Someone who gets a tabloid reporter to record the content of the case files, and Mr. Ansell has been told by Mr. Cooper during his mandatory examination that it was Mr. Rapke who had brought the reporter in. Mr. Ansell will file evidence about that. Now, any person that does that is fundamentally unqualified to be a lawyer. They do not meet the character requirements. Therefore, that's how the law operates. There is a presumption that goes against them from then on. So when we allege that they have done something mischievously, we allege that with the benefit of the presumption that they do not meet the character requirements of being a lawyer.
Mr. Kuksal, I think we're just talking now and wasting time, aren't we?
No, Your Honor, the significance of this is that what I'm saying is the court is essentially.
Is this part of your recusal application?
That's right. Now.
No, Mr. Kuksal, I think what I'll say is that in any further recusal applications you bring, I am going to require you to prepare a written submission and file and serve it in advance of the hearing, because it seems like that we have got into a practice where half a day, at least, of any time we convene, is taken up with a recusal application.
Can I just say, that's unlawful. I can identify authority because.
All right, well, I see it differently.
Because there's two, constitutional right.
Anyway, I haven't sent it, I haven't done that now, so you resist that?
Absolutely. I have a constitutional right and I can identify authority specifically.
All right, well, let's not talk about it now.
Yes, I have a constitutional right to raise the matter in court verbally and on the spot as things develop. And the court does not have the power, it's beyond its jurisdiction to stop me from doing that. And I can identify authority, but the core principles.
Anyway, what else have you got to say on the recusal application?
Can I just point out this authority, by the way? It's our.
Well, what has it? What does it establish?
It establishes the limits on the exercise of judicial power and sets out that some actions are superworse or repugnant to the concept of judicial power, that their exercise would not constitute a legitimate exercise of judicial power.
No, what's the case?
There's two cases that go towards that. It's RV Trade Practices Tribunal ex parte Tasmanian Breweries Pty Limited 1970 123 CLR 361.
1970?
1970123 CLR 361.
Yes.
So that's one of them, and in particular I would point to a few paragraphs here that are relevant.
Just give me the other.
The other, alright, so the other case is Condon v Pompano Pty Limited 2013 252 CLR 38, and again there's a few relevant paragraphs, but I'm just going to read this. I think it encapsulates the spirit of it. In 123 from the judgment of the majority, the relevant principles have their roots in Chapter 3 of the Constitution, as Justice Gummow explained in Farden. The state courts and the state Supreme Courts in particular have a constitutionally mandated position in the Australian legal system. Once the notion is rejected, as it must be, that the Constitution permits a different grades or qualities of justice, and it is accepted that the state courts have the constitutional position that has been described, it follows that the parliaments of the states may not legislate to confer powers on state courts which are repugnant or incompatible with their exercise of the judicial power of the Commonwealth. As Justice Gummow further pointed out, and is now the accepted doctrine of the court, the essential notion is that of repugnancy to or incompatibility with that institutional integrity of the state courts which bespeaks their constitutionally mandated position in the Australian legal system. And I'm just going to point out one other authority that ACTS in conjunction with it, and that's Kirk and Industrial Relations Commission.
Kirk, I'm familiar with Kirk.
Yes, so in that the court had said that it is an essential character of the Supreme Court of the state that it will view the decisions made by inferior courts and administrative bodies. It's an essential characteristic.
Right.
An immutable characteristic.
Thanks, Mr. Kuksal.
So, Your Honor.
I'm going to reserve on your recusal application. I'll put something in writing again.
Okay, can I just also refer Your Honor to a journal which is called Purpose and Context in Statutory Interpretation?
No. Why? What statutory interpretation are we dealing with here?
The interpretation that the Legal Services Board could be entitled to essentially make a decision about the validity of Mr. Ansell's practice.
Look, I don't think that's going to help me on the recusal application, Mr. Kuksal.
But, Your Honor, it's a fundamental principle of statutory construction that the court cannot presume that the law or a section acting in isolation could have the effect that Your Honor has implied it does.
All right, Mr. Kuksal, it's now 11:15, 9:30, 10:30. You've been going for 2 3/4 hours.
Okay, I request then that we, and again it's unfortunate that I have to request this because I have a right to file evidence. But I request that we be allowed to exhibit the documents that were before the court in the other proceeding before the court had made the decision.
Well, I don't know what you're talking about.
So the letter that the court had been, the documents that the court had considered before filing and before publishing the reasons 291 and 367. We want to file them in this proceeding.
What documents?
So there was the affidavit of Ms. Lulu Zhu of the 4th of June.
No, Mr. Kuksal, I'm not going to let you.
But that was the evidence before Your Honor. If Your Honor gives a judgment without, so the problem we have now is when we appeal the judgment.
Mr. Kuksal, I'm going to.
The evidence that was before you in those judgments should be in this proceeding because when the appellate court considers it, it should have the full context. Those matters are raised. You're deciding on those matters. The fundamental allegation is that you have tried to suppress information in your judgment or dishonestly ignore it, and we say that the evidence is of such intensity that it couldn't have been honestly omitted.
Mr. Kuksal, I'm not going to have, look, I'm against you on that. You can refer to that in your appeal material. I'm going to rely on paragraph.
The evidence that you've referred to in the judgments.
Which judgment? Take me to the judgment you want me to look at.
Okay, let's start with 367, and this should.
So, what are you?
So let me just bring this up, Your Honor. So in paragraph 6, you say, I've considered Mr. Kuksal's letter. I'm saying you should allow us to put the letter into evidence. The letter and the documents that accompanied it, because this is what you considered. Similarly in 291, the evidence that you referred to when you say that they make allegations that I've done.
So in 291, yes, what paragraph?
Your Honor, let me just bring up the judgment. I hadn't opened it up at that stage. But in that judgment, Your Honor says that I reject that I have done what they say that I have done.
Ms. Zhu's affidavit?
Yes.
The affidavit that was filed from?
Yes, that's right.
Purported to exhibit all those other things?
Yes, we say that we have a right to file that, and the court cannot.
I'm against you, Mr. Kuksal. In your appeal you can say, these are the documents.
But on what basis, Your Honor? It's relevant and you can't stop us from filing relevant.
Mr. Kuksal, move on please. I'm not going to.
We would like reasons for Your Honor's decision too.
I take the view that if I dismiss your recusal application and you want to appeal that, you can produce to the appeal court the documents that are relevant to these earlier decisions.
Yes, but you can't. You need more than that to stop us though, because…
Mr. Kuksal,
Your Honor, you're stopping me from raising a point. The point that I'm raising, and this is a different point, is that the judge has no power to determine the admissibility of the evidence.
Yes, Mr. Kuksal, enough. This is an interlocutory application that I recuse myself. You're now trying to you're relying on reasons I've made in other decisions which refer to documents
which prejudged the issues in this proceeding. What you're doing is prejudging that the LSB was authorized to cancel his practicing certificate when in this proceeding.
Mr. Kuksal, you want them in this proceeding, you're seeking to rely on that for the purpose of this recusal application.
Not just that, we would anyway need to.
No, I'm not dealing with it. No, I'm dealing with the recusal application.
But, Your Honor, we have a right to file evidence. The only reason I have not.
Mr. Kuksal, I'm dealing with a recusal application which has been brought without notice. Right, and now at 20 past 11.
There's nothing.
At 20 past 11, or almost, not quite. Yes, at 20 past 11, you're saying now you want to tender evidence in the recusal application. Is that correct?
Your Honor, that's not the remarkable aspect of the proceedings today. The remarkable aspect is what happened next, which if I had done to a judge who had followed the law.
Have you finished your recusal application?
Sorry.
Have you finished your application for recusal?
Well, there's another basis now for Your Honor trying to stop us from.
No, Mr. Kuksal, I'm not interested. I'm not going to let you further develop it. To just complain, we're in an endless loop where you are now applying that I recuse myself because of the way I'm handling your recusal application.
Yes. Absolutely. That's a legitimate basis too.
All right. Well, I've said to you, Mr. Kuksal, I take the view that if I dismiss your recusal application and you want to appeal, and I don't see why you wouldn't have the ability to produce to the court on appeal the documents that are referred to in the reasons in the other matters that you say justify the recusal.
You need more than. What you're saying is that you don't see that as a particular prejudice, but why are you stopping us? What's the harm in us filing the document? What's the harm in us filing the document relevant to the matters in the proceeding anyway? And we say that, in stopping us, it gives the impression that you're trying to block evidence against VLSBC from being adduced into the proceeding. That's the basis of the recusal. That is a natural implication that arises, especially given everything else that Your Honor has done.
All right, Ms. Zhu, do you adopt the submissions of Mr. Ansell, Mr. Kuksal?
Yes.
I couldn't hear that, I'm afraid.
Yes. I have dollar.
Mr. Ansell, do you adopt the submissions?
Yes, Your Honor.
Thanks. I'll reserve on the recusal application, Mr. Kuksal.
Your Honor, so are we still being prevented from filing the evidence?
I'm not going to let you file those affidavits in this recusal application, which is all I'm dealing with at the moment.
Okay, can we file?
Can you mute, Mr. Kuksal, please? Mr. McAuliffe.
Yes, Your Honor.
The situation seems to be that Mr. Kuksal is certainly presenting arguments to the effect that there's no point setting down his or the plaintiff's applications, in particular those first 3 paragraphs of the amended summons, for hearing because there's many steps between now and when he'll be in when they should be heard, that is, there's issues of subpoenas, and there's the issue of the Attorney General and the recusal application. What do you say I should do in those circumstances?
I say that Your Honor should still set down for hearing particularly the amended summons of the defendants alongside the paragraphs 1 to 3 of the plaintiff's summons. The matters of the, in relation to.
What if I'm persuaded by Mr. Kuksal that there's no point really in setting his matter down because he'll just say he needs more time?
Well, then the defendant would still seek to proceed on our summons.
Righto. Does your summons require me to make, on the way you present argument on your summons, does it require me to make findings of fact?
It would require Your Honor to have regard to the evidence that's been filed in relation to the defendants as to the authorization and the appointments. So that is my understanding of why Your Honor has also determined to hear alongside the defendant's summons paragraphs 1 to 3 of the plaintiff's summons.
But is your summons directed at the forum in which the proceeding is being brought, or is it directed at the substance of it? Are you saying that on no view of the evidence could the plaintiff win, or are you saying that the way the case has been structured, it's an abuse and should be struck out? Do you see what I mean? If your argument is the former, then it's difficult to have it determined separately.
Yes, I understand. As per the amended summons, it's put in on both limbs and in the alternative. I should emphasize, though, that the defendant's amended summons is directed only to the plaintiff's further amended summons and not to the originating motion.
I thought it was both.
Sorry, it is both, but the way in which, the point that I just wish to address there is that there was some discussion merely hours ago now just about the connections between the originating motion and the further amended summons.
Yes.
Now, our understanding and I'd understood that, essentially, the further amended summons had superseded the originating motion. Hearing from Mr. Kuksal this morning, I understand that's not the case, and
It's not the way he sees it. He says that he said what he said, but it doesn't.
Yes.
Sort of clarifies it or narrows it or seeks mandatory relief rather than declaratory relief.
That's so. So in those circumstances, it would be pressed on both bases against both of those documents, against the plaintiff's originating motion and the further amended summons.
But what I'm trying to work out, we've got a situation where there's potentially a complicated factual dispute to be resolved. The plaintiffs are saying that can't be set down now. You've got a summons, and I'm trying to work out what to do with your summons, whether to delay that until such time as, or the evidence in the matter that is the material the plaintiffs wish to put me is able to be put before me, or whether there's any utility in hearing what might be said to be sort of more technical arguments about the utility of it, the structure of it, the nature of it, all those sort of matters that you've addressed in your written submission because you filed the written submission. Those are your characterizations of it in the written submission you served some time ago.
Back in November 2022, I understand. Yes, and that was before the summons, a leave had been granted to amend the summons.
I know, but as I was looking at those submissions, as I said, I was trying to work out whether this is an attack on the framing of the case, so to speak, the structure and framing of the case, or whether you're saying on no view of the evidence could the plaintiff ever get any relief, and I think you've said to me it's both.
Yes.
So,
there would be, in terms of progressing the case and dealing with other issues in dispute, there would, of course, be benefits if the court was only to deal with the more technical aspects of the defendant's summons as to the form of the case that the plaintiffs.
All right, so that would be yes. All right, I'm not going to limit you, but you would say those aspects of the case that do not require me finally to determine the factual issues underlying it. Now, I'm going to think about this. If I were to try to have that dealt with separately, what orders would be required to achieve that? Presumably, they'd have to exchange of submissions.
Yes, further submissions would be required.
Yes. Now, Mr. Kuksal would have to, and the plaintiffs would have to get your submissions and be in a position to respond to them.
Yes.
All right, okay, so I'm just trying to think of the extent to which there are.
I'd like to address the court about it.
Yes, all right, I'm not talking to you at the moment, Mr. Kuksal. I'll come back to you.
Yes, but I'm just saying before the court.
I'll come back to you, Mr. Kuksal. There's the question of the originating motion and the summons, their interaction, how the proceeding is commenced and so forth. There's the question that I raised with Mr. Kuksal about the fact that the 3 people are no longer there, and Mr. Kuksal says,
Your Honor, I object to this, by the way.
Mr. Kuksal, can you put Mr. Kuksal on mute, please? And Mr. Kuksal's, what he said about the purpose of what is, and then there's the question about whether there's any evidence that could support his allegations, and it's, the third one that I see is, at least the third one is difficult to have dealt with separately from Mr. Kuksal's case, but I'll perhaps reflect on that. So what, assuming I'm not going to force Mr. Kuksal to present, and I'm going to reflect on this, present his case, so to speak, on the merits, that is, to lead all his evidence, in the next short time because of the issues he's raised, what orders do you say I should be making, that there should be your summons, nonetheless, set down to be determined at least in part?
Yes, Your Honor.
An exchange of submissions, and would there have to be any further affidavit material?
Not from the defendant's perspective given we have filed that further affidavit in the interim.
Yes.
In relation to other orders about other matters, if I might address that briefly, the subpoena issues could be dealt with concurrently. So in terms of whether or not an additional draft is circulated because Your Honor, of course, in relation to.
Well, did your client buy into the subpoena issue last time? I can't remember.
Only to preserve any objections that might occur in the future. Yes.
Yes.
That was the only extent of it.
Right, so I'll deal with the subpoenas.
And could I just emphasize just on that point that, just very respectfully, there seems to be, from our understanding in some of the emails that have occurred, there seems to be some conflation between this proceeding and the injunction proceeding about the subpoenas that had been issued because in this proceeding, Your Honor gave oral reasons back on the 17th of May in relation to the refusal to permit the subpoena to be issued against the Chief Commissioner, and granted the application for the subpoena addressed to the Victorian Legal Services Commissioner to be issued, but then the written reasons about the subpoenas against those two individuals were given in the other injunction proceeding 03994. So Your Honor has actually given reasons orally on the last occasion about that subpoena issue, that.
Yes, I don't think Mr. Kuksal was disagreeing with that. I think he was saying that he's since modified the form of the subpoena, and I haven't given reasons or made a decision in relation to a modified form of.
Yes, no, I accept that that's what he said today. I just wish to emphasize that if there's, to the extent that Your Honor has not given any reasons, Your Honor certainly did on the 17th of May.
Well, initially, yes.
Yes.
Initially, it's on the subpoenas where he made some changes.
Yes, that's so. So in relation to those subpoenas, if leave would be granted or is to be granted in relation to a modified subpoena for any return date, of course, that would still preserve the Commissioner's, or any Commissioner's right to object to that subpoena.
Yes, no, I mean, it goes without saying that the addressee would have the rights they normally have, and Mr. Kuksal, in fact, he emphasized the fact that the addressee has that right in support of his argument that subpoenas should readily issue.
That's right. And the only extra order that I would seek in addition to this, dealing with the subpoenas concurrently, is that these objections would be dealt with on the papers.
Well, I don't know if I can foreclose that point. I mean, it might be that the addressee, so the addressee is the Ms. Maclay, for example, she might have a different. Are you saying that you're acting for her or?
My solicitors certainly are instructed on behalf.
Well, look, I think we'll cross that bridge when we come to it because.
Certainly, Your Honor.
The addressee of the subpoenas might have a view about that.
Yes, just turning to another issue, this is just the chartered notice matter.
Yes.
In my view, S35 of the Charter of Human Rights and Responsibilities Act provides the processes to the notice that must be given either to or both the Attorney General and the Commission, VIROC.
Yes.
There is in addition, of course, the Supreme Court's own practice note for notification of matters under that provision, and that Supreme Court General Practice Note No. 14. Now, in my reading of S35 and the other provisions as well say the practice note, it doesn't seem to require the court to seal a charter notice, and it certainly, in my submission, does not compel a court to order either the Attorney General or the Commission to be joined.
No, I didn't understand Mr. Kuksal to say that the court was required to order their addition. He anticipated making an application for an order that they be added.
Yes.
And that's when I said to him that it might be that they would want to be added.
And that might be the case. They might seek to intervene and there's no issue, and so we could move along from there, but if there is to be an application that they be added, of course, the court has its own power to join them under its rules, but I would submit that any such application for joinder separate to the charter notice intervention should be made properly, so on summons supported by affidavit.
I think that, I'd be surprised if Mr. Kuksal disagreed with that. I thought that he was indicating that he would do such a thing.
Well, there seemed to be, respectfully, some conflation between the words.
Your Honor, he's misrepresenting matters. He's lying.
Just keep Mr. Kuksal on mute. I'm going to come back to you, Mr. Kuksal.
Between the issues of joiner and intervention because the Attorney General and VIROC under the Charter have those rights of intervention, and within those provisions, of course, they may be joined as parties. That's, in my submission, only if they determine to intervene. So if they don't determine to intervene, then it falls to the court under its own rules to deal with a joinder application.
Yes, right. Anyway, as I say, we can cross these issues, cross these bridges if and when we come to them.
Well, the issue that I raise, in my submission, they should be dealt with in procedural orders because under the practice note, it's paragraph 4.6 it seems that the attorney and the commission require an ordinary period of time to be able to respond to notices. So that's about 14 days. So in my submission, if Mr. Kuksal or the plaintiffs wish to issue the charter notices or make application under the rules for joinder, then it should be done in a timely manner so the Attorney General and the Commission can have time to consider it.
Yes, so there'd be a date by which any such notices are to be served, and then there would be a date by which any application to add them be filed.
Yes, that's my submission, and, of course,
it makes sense to me.
There might be no need for an application if they determine to intervene.
Yes.
Yes.
Right.
Otherwise, in my submission, there should still be consideration given to a second timetable to proceed towards resolution of the substantive case, and that may be involving such things as the plaintiff filing any further affidavits or submissions as required.
Yes, but Mr. Kuksal would just say, I can't deal with that until the subpoena issues have been sorted out.
The plaintiffs have still filed the applications and brought this case.
I know they have, and I raised this with Mr. Kuksal at the beginning when he said, we want an expedited hearing. We're ready to go tomorrow. Let's get on with it, and now he's saying, we can't get on with it until we've had all these subpoenas answered, but his response to that was, we've found out more material as the matter has gone on.
I understand that that's the case. I think my concern and my client's concerns are the incremental pace that the substantive proceeding has taken in relation to dealing with the orders and the relief that's being sought by the plaintiffs. So the problem is, and I would pick up similar language, that at some point, the loop of issuing further subpoenas, or seeking more and more materials, or further amendments, or joinders of other parties would need to be ended, so we can progress to dealing with the substance of the issues.
Yes, at some point. The question is, at what point?
Yes, and the reason why I raise that is, of course, there was another summons that was floated, as I understand it, in May, in relation to joining a person called Ems and Naz, and also the IBAC. And Your Honour granted leave for a summons, for a subpoena to be issued in the form as it was circulated in February, and that was not done. And so the issue that I'm raising.
There's delays. I see there's delays.
Yes, there's delays.
Yes.
And non-compliance with those orders. And I accept that from Mr. Kuksal's perspective, that February version of the subpoena was not.
It wasn't dealt with until later. Yes.
Yes, we're still at a point where there are delays, and that they had filed their application.
I understand your point, Mr. McAuliffe, which is, you're urging me to just get on with it.
That's so, Your Honour.
All right.
There's just two further matters to deal with. The first is, and I just would inquire whether this would assist Your Honour, there were some submissions made in relation to SS 463 and 464 of the Legal Profession Uniform Law. It may be a matter that's more properly dealt with in the substance of the hearing of the plaintiff's originating motion. But against that provision is, of course, within the Act itself, the Application Act, is S 155. Now, S 155 refers and states explicitly that nothing in the Uniform Law excludes or restricts the Supreme Court's judicial review or inherent jurisdiction powers.
If I'm remembering SS 463 and 464 correctly, are those the ones that say that if a decision is set aside, then it's as if it never happened?
It gives a court or tribunal powers to vary or make in substitution a decision as to the original decision-maker.
All right, well, that's consistent with the court's judicial review power continuing, which is what S 155 says.
Yes.
The point that arises on SS 463 and 464 is, what's to happen in the meantime? Mr. Kuksal has one view, and he says I've wrongly taken another view in the earlier decision.
That may be so, but my submission that I make about 463 and 464 is, when that's read against rights of appeal or review that are scattered throughout the Uniform Law, and the two easiest examples are a right of repeal or review under Regulation 100, in relation to practicing certificates, and a right of appeal or review about the appointment of an external intervener under Regulation 358. It's very apparent that 463 and 464 are dealing with those rights of appeal or review under the Uniform Law, and not granting some sort of new species or subject of judicial review power. It cannot be the case that 463 is granting a Supreme Court, in the exercise of its inherent jurisdiction of judicial review, some new ability to grant an extra relief to vary a decision that was made. So that's just the issue that I raise. It may be that can be reflected on.
I'll have to have a look at that. Yes. I'll have a look. I may have to have a look at it.
Now, the other issue, and the final one, just to say very briefly, is of course, some of the matters that have been put, particularly in relation to the conduct of Mr. Rapke and others today have certainly been put to Your Honour by the bar table. That is not accepted by clients, and that's all I will say on the matter.
Thanks, Mr. McAuliffe. Again, I'm going to reserve and reflect on this. If I decided to set down your summons in the shorter term, how long would your client need to put in a submission?
2 weeks would suffice, Your Honor.
2 weeks. Yes. All right. Is that what you had to say, Mr. McAuliffe?
Yes, thank you, Your Honor.
Thank you, Mr. Kuksal. You wanted to be heard on the proposal that the strikeout summons, to use a convenient shorthand, be determined insofar as it relates to matters of form, so to speak, before there's a full factual investigation. What do you say?
First of all, Your Honor, I think it was highly improper that Your Honor was effectively feeding suggestions to Mr. McAuliffe. The transcript will show that, about how he.
Yes.
Your Honor, I should be allowed to say this. I've not said this before. I'm not repeating myself. I think Your Honor was inviting and predisposing what orders he would be willing to make, and then inviting the LSBC to make corresponding applications in order to effectively act in conspiracy with the LSBC.
Mr. Kuksal, I was responding to having read their submission. Anyway, would you answer my question about, do you object? What's your position in relation to?
Your Honor, I have a few things to say, and they're all in response. They're not previous matters, so I should be allowed to say them. Mr. McAuliffe wasted a lot of the court's time on completely nonsensical issues, and
Mr. McAuliffe spoke for about 10 minutes, didn't he?
it doesn't matter. Those were 10 minutes wasted.
All right.
He was.
I just think it was an unnecessary.
Everything that I'm raising, I have a right to raise. What he said was scandalous.
What did he say that was scandalous?
Well, first of all, he tried to misrepresent what I had said and then tried to.
Mr. Kuksal, I'll just shut up. You tell me what you want to say.
You asked me. I have to answer this.
Yes.
I have always said that the joinder application should be on summons and affidavit. He implied that I had said something else and then sought to correct me and said it should be on summons and affidavit. I think Your Honor already pointed that out to him, albeit not directly enough.
Mr. Kuksal, did Mr. McAuliffe have any notice prior to this morning that you would be raising these issues, and discussing and talking about adding?
Doesn't matter. He heard it. If Your Honor could grasp what I said, he could grasp.
Okay, so are you accusing him of deliberately?
Absolutely.
And falsely?
Absolutely. Your Honor, this works in conjunction with everything else that has happened. The way Your Honor looks at things, in my view, is wrong because the way these things need to be looked at is on the basis of conditional probability. Everything put together provides context and eliminates possibilities.
All right.
I'm presenting a case against McAuliffe. I'm developing it.
Mr. Kuksal, I'm not interested in hearing.
Present it today, but I will later in this matter.
Can you mute Mr. Kuksal for a moment, please? Mr. Kuksal, I'm not interested in hearing you further develop at the moment any criticisms of Mr. McAuliffe, all right? I just want to hear your response to the submissions and suggestions that he made. Unmute Mr. Kuksal.
I think what Your Honor said is antithetical to how a court should govern itself and the obligation that the court has as the exclusive authority to regulate the legal profession. To clarify, the purpose of what I'm saying is not to seek relief against Mr. McAuliffe at this stage. I'm simply identifying the incorrectness of the submissions so as to prevent Your Honor from making the wrong order on them.
Okay. So the use of the word scandalous was unnecessary.
No, it wasn't. It wasn't incorrect. It was more than. I think that depends on the perspective one takes, but I think it was necessary for context.
All right.
It contextualizes that the orders are being sought in bad faith, and that leads me to the next point, that I think the whole exercise was futile. Of what I say was an implicit conspiracy between the bench and the bar to prevent us from seeking justice in this matter through technicalities, because when they, even if they had that, first of all, summons on the basis of the ostensible, let's say, invalidity of our originating motion would be the summons that they have already gotten amended. If they could proceed on that basis, they wouldn't have had to amend the originating, the summons. What Your Honor is saying is, can we cancel the amendment to your summons to the, and proceed on the basis of the original summons? They know that it's defective. They can't proceed on that basis, and that's the first thing. And then I think it was also, inherently self-contradicting to say that you proceed on the basis of the invalidity of the originating motion, but, well, you need to find evidence about that. That particular principle or provision then precludes the finding of evidence. That's the first thing. Also, even if they did that, that doesn't stop us from subpoenaing evidence to say that that has been done in bad faith and that it's an abuse of court process. The court still has to hear and decide that, and we will do that. Your Honor had misrepresented my position that the evidence was necessary only for my three, or only for orders that sought through my summons or our summons or the originating motion. We also needed to answer their originating motion because we say that they brought it as an abuse of court process, and when that allegation is made, the court has to hear it, especially when it's made against the executive. That's what was said in Strickland. Our application, then, is an application that their summons is an abuse of court process, and we make it on the basis of the evidentiary limb or the evidential limb. So you have to hear our application before you hear theirs, because otherwise it's rendered nugatory and it brings the administration of justice into disrepute as per Strickland. The other matter is that he scandalously suggested that there was an incremental process in this proceeding of seeking more relief. We're not seeking more relief. We're just seeking evidence. He also implied that we're filing further subpoenas or making further applications. We're not doing that. We're saying, at least honestly here, the first set of applications. We haven't issued a single subpoena. It's not that we issued a subpoena, it got dismissed and then we were wanting to issue more. We're saying that the court is trying desperately to prevent us from filing evidence in this matter, and it has, corruptly prevented us from issuing the subpoenas, and the court hasn't answered that. By the way, it was improper for the court to spend time on matters that could only have been utilized if Your Honor did not recuse himself, and I have specific authority where a similar issue or in very similar circumstances the appellate court have found that doing that certainly gives rise to a reasonable apprehension that the judge is predetermined to dismiss the matter, because logically speaking, a judge would not waste time, antagonize a party and do all of those things if they were completely uncertain about whether or not they will continue. And the point here is that you need a possibility, not a probability. It certainly raises a possibility that some reasonable person can think after that the judge is making all these plans and entering these extended discussions because is predisposed to rejecting the recusal application anyway. So I can cite authority if Your Honor allows me to, but that is the principle, and we say that betrays the agenda that Your Honor has about preventing us from holding the VLSBC and co-conspirators to account. The other matter that I raise is that Mr. McAuliffe has this tendency to say that inferences that must be drawn as a matter of the operation of the law should not be drawn because his clients are not permitting the court to draw them. The whole point of inferences such as the sort that were drawn in Jones v. Dunkel or Brown v. Dunn, or inferences about the consciousness of guilt, post-offense conduct, so on and so forth, the point about the principle of law that operates is that when serious allegations are made against vulnerable parties, it is offensive to common decency that those allegations not be addressed, and any honorable person would take the time to address those allegations. And when those allegations are specifically made against a lawyer, then it brings the administration of justice into disrepute if those allegations are not addressed properly, and I refer the court in particular.
So you're talking about allegations. Just tell me what allegations you're referring to.
So Mr. McAuliffe said that the court should not draw any inferences from the fact that we have made allegations and presented evidence of wrongdoing against Mr. Rapke.
I don't think, he just said they're disputed. He said they don't accept that.
No, he says, yeah, but it was for the purpose of the court not drawing inferences. They're not.
No. All he was saying, he was putting on the record, you has this morning orally said that other people have engaged in misconduct. As I understood it, Mr. McAuliffe was just putting on the record that it's not accepted by his side that they've engaged in misconduct.
I'm saying he can't say that because
Right.
No, Your Honor, you have to hear me. This indicates that you've already dismissed my submission. What I'm saying is that in order for there to be a legitimate dispute about it, there has to be evidence that there is a legitimate dispute. They need to file evidence and address our allegations specifically and say that, if nothing else, just say that Mr. Rapke should file an affidavit and say that, I did not do this, what they're alleging that I did. That Mr. Ansell has given evidence of matters that were specifically discussed between him and Mr. Nayland on the phone. There's further documentary evidence that we have that contextualizes that happened, contemporaneously recorded evidence, but Mr. Nayland cannot fight that documentary evidence, but at the very least, if he thinks that Mr. Ansell is forging evidence and basically committing further offenses of perjury, then the least Mr. Nayland can do is simply say that on oath. Mr. McAuliffe can't say from the bar table that basically, my client is not doing that, but also you should not interpret anything out of it. So if they are not disputed, is his position, it is a scandalous position. It is a ground for professional misconduct proceeding against him, especially in conjunction with all the scandalous stuff that is done, including raising with the courts that Mr. Rapke could have waived my legal privilege on account of his position as the external manager of the firm. He also directly lied to Justice Gummow. We've raised that in evidence in this proceeding about.
Mr. Kuksal, so what are you addressing all this about now, really? I mean,
Well, Your Honor, I know you're uninterested in the offenses.
I'm uninterested in hearing allegations that Mr. McAuliffe has behaved in a scandalous manner.
Well, I'm saying that, Your Honor, I am using that as context for the fact that we say that their summons is being advanced as a mischief.
Yes.
And
isn't it either a good summons or a bad summons?
No, that's what Strickland says. Even if, so the principle is this. An executive body can use the law for an improper purpose, and when it does, the court must stop it. And Your Honor, I will refer to a specific paragraph of Strickland as well and clarify this further. This is,
You referred to paragraph 153 before.
yes,
What is the citation again?
2018266 CLR 325. So that was just one. I'm not only relying on that paragraph to clarify, I'm relying on the authority as a whole, but I use that paragraph for its rhetorical value, And I'm going to just refer to another paragraph for its, concise summarization of the principle that I'm relying on. And I'm just bringing up the judgment again, I had closed it. Thank you. So, this is, I believe it was essentially, I'm going to not spend more time. Okay, yeah, found it. This is the judgment of Justice Edelman in Strickland, the same citation, obviously. I'm reading from paragraph 246. Suppose that, before charging a person, the police or prosecutors seek to resile without cause from a written indemnity from prosecution given to the person. Or suppose that a suspect is charged after the deliberate invasion.
Mr. Kuksal, I've got a copy of it up in front of me now. So, I can read paragraph 246.
247, 248, 249 re-emphasize, and generally 250 to 273 are relevant. And again, we stress also.
In support of the proposition that the defendant's summons is brought for an
In support of the proposition that Your Honor is wrong in saying that either it is legally valid as a matter of technical compliance with the law or not, and no other argument can be raised. We say that we can also raise the argument that they're abusing the court process and infringing on human rights in bringing the summons because.
That's what I meant.
Yes, and I rely on the whole judgment generally, but we're stressing those paragraphs, and what we're saying effectively is that if the court doesn't hear us, then the court is further portraying its corrupt intentions and bringing the administration of justice into further disrepute if that's possible. And we say that the court doesn't need the LSBC's position if it were operating lawfully to draw inferences, and as a matter of, what they're doing is a waste of time because first they amended the summons. Now, taking up the court's invitation there, so first they amended the summons. We fought them. The court made costs orders against us for fighting it. Now they want to go back to the first summons so they can advance the matter anyway. Nothing else is otherwise possible to prevent us from. All we want is for the truth to come out in this proceeding. That's all we're asking for. We're not asking for anything else. We're asking for the truth about the controversies in relation to the LSBC's decisions to come out, and Ms. Zhu says that she wants more than just the truth. She wants relief as well. But what I'm saying is that fundamentally we're seeking the truth to come out as a prerequisite, and they have an obligation as a model litigant and also as a member of the government or an agency of the government to have the truth come out. They have an obligation to admit when they've done something wrong, and when they don't do that, they're not acting as the statutory body. They're acting as corrupt officials that are usurping the authority of the statutory body out of personal conflict to evade personal liability. Misfeasance is a personal tort. Those people have themselves broken the law and committed criminal offenses. They're hiding behind the Legal Services Board's name, and it is already prejudicial for us to have to allege that the Legal Services Board did something when it did not do. The corrupt people there did something and abused the authority that they had. So we're saying that the court cannot schedule the summons. It's scandalous that it's even considered because of all the matters raised, and in any event, we would have the right to issue subpoenas about that. Also, that matter would have to wait until the determination of the joinder application, and that brings me to another issue. He sought to nervously and improperly argue against the fact that I have a right to join the Attorney General, and again he did it dishonestly because he implied that I have only relied on S35. I had specifically said that the right to join the Attorney General comes from S34.
Did you say you've got a right to join the Attorney General, or the right to apply to join the Attorney General?
I say that I have a right to join them. I clarified repeatedly that I have a right to join them, and I said that.
So you don't actually need to make an application then?
No, we have to make an application because what the court has.
But it's an application that can't be refused.
What the court has to decide is that it is being done for legitimate purposes.
Okay.
That I'm not, for instance, simply joining them when there is no human right issue. They can only be joined, the right is.
Anyway, so suppose you're right that Mr. McAuliffe has missummarized or misunderstood or misstated what you said about the joinder application. Where does that go?
Section 34, Your Honor, leaving open the possibility that he hasn't mischaracterized what I've said.
Look, you've said a lot, Mr. Kuksal. Sitting here, I couldn't myself recall whether your point was that you've got a right to make an application or you've got an automatic right to effect a joinder.
Well,
whatever you said, you seemed to work on the basis that you had to make an application.
Your Honor, the making of the application is a formality like seeking the court stamp to issue the subpoena.
Yes, right.
The point is to prevent abuse of court process.
All right.
If there was no, let's say, administrative check on the process, then people like Mr. McAuliffe and his clients could potentially abuse the court process for dishonest purposes.
All right, let's keep going, Mr. Kuksal.
Yes, but, Your Honor, the point that I'd specifically raise is that Mr. McAuliffe tried to conflate the issue and imply that I had only identified S35 of the Charter as the basis of the right to join the Attorney General.
Yes.
That's clear that he said that 35 is what I rely on only and 35 does not actually give rise to that when I had specifically clarified that it was 34.
All right.
So, he lied about that, and if Your Honor could grasp what I was saying, and it's not something that he can be snoozing his way through. Because I'm making serious allegations. He should be making notes and...
He's doing it on the hop because no notice has been given of any of this stuff.
Yes, but I'm making sense if a person can ask what I'm saying.
All right.
It's not a complicated thing.
Move on, I think, Mr. Kuksal.
Okay, so the point is that the court will have to decide the matters of joinder, and let me also clarify, because of what Mr. McAuliffe has tried to do, that the notice, so he says that the court doesn't have to seal the document and all of those things, which is basically irrelevant. The point is that the Attorney General must know that the notice was actually filed in the proceeding. That's why the seal is normally there, but again it's not a matter of substance. The matter of substance, though, is this. Under the Judiciary Act there is a separate provision to notify the Attorneys General of all the states of a constitutional issue. We're relying on both, as I had clarified. We're relying on the Charter and we're relying on the Judiciary Act, and we're relying on it in relation to the orders that Your Honor has made and the fact that Your Honor has taken the position that an allegation of corrupt conduct against a judge does not need to be factually determined, or it doesn't need to be determined whether it's been raised in bad faith before the judge continues. We say that's a constitutional issue, and we say that the court has to give the Attorneys General an opportunity to intervene after we file the notices in this proceeding and in 3994. We will write to the chambers separately and address this. So we want to raise those constitutional issues. The court cannot take any next steps anyway until it has given the Attorneys General an opportunity to intervene. That's a legislative mandate. The court would be breaking more laws if it were to deny us that.
All right.
So we say that firstly the court needs to address each point that we've made. It's unhelpful that the court has not allowed us to file or prevented us from filing evidence, and I say prevented because the court has. The registry from.
Address each point you've made orally today. This court has to address each point you've made. What are you referring to?
No, but what I'm saying, we weren't allowed to file the evidence and.
Okay, but you told me that the court has to address each point you've made. I'm just clarifying that you're talking about the oral argument presented this morning.
Oral arguments, and also the arguments in one of the oral arguments is that the court had not adequately addressed the evidential matters that had been raised in Ms. Zhu's affidavit and in my letter. Now, because I haven't gone through each of those things because Your Honor wouldn't let me, I think it is just unreasonable and extremely unfairly prejudicial to us that we're not being allowed to file that evidence. It becomes even more relevant every time Your Honor goes against it. The other point is that the court does not have power to rule that an evidential document is inadmissible without objection from the other side, and the weight of the document or the weight of the evidence is irrelevant to its relevance or its admissibility if they're not objecting to it. The court cannot stop us from filing evidence. The court has directed the registry not to accept our documents unless an order is made. That's the only reason I have to raise this now, and we say that, by the way, is also an unlawful abrogation of our right to due process in court proceedings, S24. And because this proceeding impinges on criminal rights, we say.
To what end are you making all these? To what end are you?
You have to address this as well in your recusal or rejection of your recusal.
You're going back to your recusal application?
Yes, we're complaining about it.
I'm not interested in your recusal application now. I've heard your argument on that. Mr. McAuliffe didn't address me on it.
Which I think is the only appropriate thing is done. The other matter, Your Honor, is that we say that the court addresses us on the recusal application, and after that there would have to be, if the court preemptively makes a decision about how long we have to file the constitution orders and the.
Well, how long do you say you would need to do that? I thought you said it was pretty much ready to go. You've been working on it then.
Yes, but after today, I will have to raise further points. That is the problem with all of these.
So how long would you need to do the constitutional notice or the, if I call it, you know what we mean, the.
Your Honor, I'd say we should be given 3 weeks to file the constitutional orders and the charter orders, and then I do not know offhand, but Mr. McAuliffe has said this about the charter notice, and I don't have any reason to doubt the accuracy of what is saying, that the law gives the Attorney General 2 weeks to respond.
Yes.
Now, I personally don't know that that is correct, but let's say that he's right about that.
Yes.
And then I don't know if the Constitution notice operates under the same rules. It would be logical that it did because the out-of-the-court rules. So that would be 2 weeks as well. But I don't know if, in my experience, not everybody responds within the 2 weeks.
Yes.
And I think there should be some margin for, let's say, 3 weeks for them to respond and clarify their position, and then as the joinder application that we're proposing, which by the way we rely on S34 and S40 of the Charter.
It would be after that.
It could be after. It could be concurrent. Because we're not relying on we don't need their position is our position.
No, I understand.
We can have authorities in support of it, but what we're saying is we have a right to.
So that could be concurrent. So there could be 3 weeks for you to file your notices. 3 weeks, and then they would have 2 weeks to respond, say, assuming that's right. Give them 3 weeks. You could have any application to join them made returnable at the end of that 3-week period.
Yes, but also I think when I said that it can brought concurrent, I said that as a matter of nothing stopping us from filing it, but I think there is some argument about efficiency, but we should wait for them to respond because otherwise we would be raising a wider application.
Yes.
ITH the presumption that they may be opposing.
Right.
When in fact they may not. But the other matter, Your Honor, is that we also need to provide evidence to the Attorney General about the basis upon which the notice is, the matters that we say arise.
Yes.
And we get an opportunity to file that and serve a sealed copy of the evidence.
Yes, I don't know if it works. I don't know if you're limited to file the affidavits in the charter notice.
No, you're not, but we still want to be able to file the evidence.
Well, yes, all right.
We want to file the evidence before we serve it on.
Yes, all right.
Your Honor, this is why we say.
You're not a position to give information to the Attorney General or to whoever the people are under the charter.
We have a right to give information to the Attorney General under that is under the Constitution. The responsible representative all within it.
Yes.
And also government agencies generally under the Public Administration Act. They are obliged to hear us.
All right, yes, but yes, you're in a position to give them the information.
Anyway, yes.
That you want to refer to show that there's, to intention.
I know, sure, but this is the peculiarity of the current situation. The allegations that we're making are, on their face, extraordinary.
Yes.
And highly unlikely, but they allege actions that are highly unlikely, and it legitimizes the evidence after it has been filed. It at least shows that it was in connection with the proceeding, but we're not just making claims that which will not actually true.
So what affidavits would you want to file?
So I want to file an affidavit, and I think.
So want an affidavit sworn by you?
Yes, I think all the plaintiffs should have a right to file the affidavit because.
But what would you be doing? Are you in a position to prepare these affidavits at the moment?
Yes.
All right, you're not saying you can't do them until the subpoenas have been dealt with then?
No, this is for the Constitution orders.
All right.
We're not saying that we will raise the orders after we get the evidence. We're raising.
Yes, so what's involved in the affidavits that you want to serve?
It's basically the proof of the fact that the controversies we allege actually arise.
So what form would that proof?
Documentary evidence. So.
But what, like?
Okay, so, for instance, let's take an example of the constitutional issue that we're alleging. One of the constitutional issues that we're alleging is that the LSBC has acted in the manner that is antithetical to its objects under the Uniform Law and the purpose of the Act itself in.
So yes, so would the.
Under my legal privilege and conspiring with the police to basically fabricate evidence against.
No, Mr. Kuksal, don't worry about it.
Well, the evidence.
You've told me that these affidavits are to do for the purposes of the constitutional or charter notice. I take the view you can give whatever information you desire to give when you're giving those notices.
Well, but we should also have a right to file this evidence in this proceeding anyway.
Well, that's a different point.
Yeah, what we're saying is it will serve 2 purposes. It will reveal to the Attorney General that these are the matters that have been raised in this proceeding.
Well, why don't I get you, because of this concern that I've had, and that you have said I don't have any right to have over the volume of material that is produced and over a tendency of one affidavit exhibiting other affidavits and the like. Why don't you prepare a clearly identified list of what it is you want to put in them?
Your Honor, that is, what Your Honor is doing is making an advance ruling without the jurisdictional facts.
No, I'm trying to get clarity as to what it is that.
Yeah, and you don't have the right to reject evidence in the first place. And what Your Honor has specifically suggested is forbidden by S-192.
Thanks, Mr. Kuksal. I'll reflect on that. Anything else you want to say?
Your Honor, I think Ms. Zhu.
Yes, Ms. Zhu, what do you want to? You're finished, Mr. Kuksal.
I think in substance, but
Are you finished or not, Mr. Kuksal?
I just want to flag that we, the court, will also need to address us in relation to the pending subpoena decisions and allowing us to file subpoenas in the matter.
Yes.
And also we want to raise the protective cost order application.
I'm not dealing with that now. If you want to do that, you can serve notice that that's going to be an application.
At this point, we're doing that, and then the other matter is that.
And why didn't you do it in the other matter? Was it the other matter where you said you were going to do it, but never did?
Because, Your Honor, the order that Your Honor had made was that we could still raise an actual bias application.
Yes.
And we couldn't file those applications until we had raised the actual bias.
All right. Let's not get into it now.
Yes, but that was the reason, because that would have meant that we were forfeiting the right.
All right.
Yes, but that was the reason, because that would have meant that we were forfeiting the right.
When you say the courts prevented you from filing, are you talking about the restrictions, the page limits that have been imposed?
Yes.
Yes.
And also
But the court has given you leave to file affidavits, but has imposed page limits and you haven't.
No, not just that, but the court has also instructed the registry that unless there's a court order, we are not allowed to file evidence.
Well, in a case-managed list, that tends to be the case.
No, they're not.
Directions are given for the filing of affidavit material and…
Yes, but people are not prevented. So before the court had directed the registry, we could file affidavits whenever.
Yes.
All the affidavits that we filed previously were filed without the orders. What the court has done.
But the affidavits, so you have filed before, a long time ago, you filed a lot of affidavits.
But the court then has specifically instructed the registry to not allow us to file evidence as we normally can or as parties normally can in breach of our right under the Charter of S34, 35 and…
And am I correct in thinking that the documents you've sought to file are thousands of pages long?
No, Your Honor, that's wrong.
Yes or no?
Yes.
I know you say that's irrelevant, but is that?
No, I'm saying that you're also wrong about that.
Yes. So you've sought to put in short affidavits that have been rejected?
Yes, because the court, they have said to us specifically that the registry has been instructed that unless there is a court order that allows us to file evidence but not to file.
Yes. And what's happened?
Now that…
From time to time, I've made orders about affidavits be filed by a certain date, etc. So…
But only in relation to a specific hearing.
Yes.
But only in relation to a specific hearing.
I think it's something that is associated with self-represented litigants, as much as any of them.
No, but again, that, Your Honor, is also completely unlawful because self-represented litigants do not have less rights.
Yes.
Represented litigants.
All right, Mr. Kuksal, anything else?
And as I say that it was our experience also as self-represented litigants that before the court had directed the registry to act unlawfully, we could file the documents, and we say that the court has, effectively, sought to, whether or not it was intentional, but the court has assisted VLSBC in breaking the law and causing unlawful oppression. So those are the matters that we raise.
Thanks, Mr. Kuksal. And Ms. Zhu had something to say.
Yes, I'm going to move so she can take my place. 1 second.
Thanks.
I just want to say that there is no utility in VLSB having their matter heard first, because even though it's dismissing technicality doesn't mean that our case doesn't have any substance and that it cannot be brought back again, so it will be a waste of their time as well. So I do not think there is any utility in their summons being heard, and I think if it's necessary, I think we should also wait until we see their submissions first and then see and be given another opportunity to see if it will be heard first or not, because right now their position is not that clear at the moment for their dismissal application before they serve the full submissions. So that's what I had. Way.
All right.
Yes. Thank you. What?
Thanks. Anything else? No, Mr. Ansell?
Yeah. Your Honor, if I could just say that in regards to the matters raised by Mr. Kuksal today, it would be my contention that this matter should be heard before the other proceeding. 3994.
Yes, Mr. Ansell, something I just meant to, may only raise for this purpose. The subpoenas that have been circulated are expressed to have been prepared by Erudite Legal and have got the address peter@eruditelegal.com.au. I just want to sort of make it clear that I haven't turned my mind to whether or not the form of the documents is in breach of the injunction that was made by Justice Forbes or not. I make no comment on it other than to say that I don't want anyone to think that my failure to raise it would be some approval or exoneration of it in the event that it was contrary to that injunction. You appreciate that?
Appreciate that.
And Mr. Kuksal and Ms. Zhu also appreciate that?
Your Honor, I say that the order had specifically excluded Mr. Peter Ansell.
I think, yes, I can see that.
So we know that and we didn't.
Yes, that's all right. And that might be right. It just occurred to me that I didn't want anyone to think that.
Well, Your Honor,
I have thought about it and excused it and approved it in any way. It's either in breach of the injunction, or it's not, and it's not something I've concerned myself with.
I think it was unnecessary for the court to say that.
Yes, I know, but I just wanted to make sure that you.
Because that email was excluded.
Well, that's right.
They had applied for it. I say this because they had applied to add Mr. Peter as well.
Right.
Justice Forbes had specifically excluded him because.
Yes, no, I understand that Mr. Ansell is not caught by the
Peter at Erudite Legal. That particular email address was also raised, and it was not caught by the injunction because Justice Forbes had accepted that the validity of VLSBC.
Mr. Kuksal, I'm not arguing, I'm not pushing back against you at all. I'm just
saying that.
Mr. Kuksal, I'm not arguing, I'm not pushing back against you at all. I'm just.
Well, Your Honor has never felt the need to clarify those issues about VLSBC.
All right, it occurred.
Well, Your Honor has never felt the need to clarify those issues about VLSBC.
All right.
You know, a sole practitioner about the fact that he could be breaking the law in continuing his proceedings against the administrative body.
Mr. Kuksal, I saw Mr. Ansell's face when I was speaking to him about it. He was across the issue. He was not intimidated or.
No. I'm raising that matter because I'm not saying that he is intimidated. Let me clarify. I don't have any basis to give evidence on his behalf.
No.
I'm saying that it raises the presumption.
What presumption?
That you're trying to intimidate him.
Come on, Mr. Kuksal. That's.
Your Honor. We've alleged that. We've alleged that you gave the last order in, as a detrimental action because you want to intimidate him. I have given an undertaking.
All right, Mr. Kuksal.
Bring proceedings against Your Honor, and Your Honor is trying to prevent me by undermining my resources.
All right. Well, I'm going to reserve along this matter and be in touch when I'm ready to let you know what orders I'm going to make.
Thank you, Your Honor.